Thank you all very much for joining this Oxfirst webinar on copyright and artificial intelligence. I think this is an extremely hot topic, particularly in light of the fact that the European Commission was supposed to pronounce itself yesterday on the Artificial Intelligence Directive, which it hasn't done so far, and we're expecting their opinion on these matters anytime soon, even though I understand copyright has so far been spared from the larger debate. Without a doubt, it will come up and will be a huge question once we have a new European Parliament. So apart from what is happening in Brussels, also the various European nations, such as Sweden, for example, but also the Canadians or the United States of America have opened the question on the relationship of copyright and artificial intelligence. So I think it is really a very global, hot debate that we are currently seeing. And I'm extremely pleased to have such a distinct panel here today to debate, discuss, and offer their views and ideas. We have on the panel Professor Dr. Martin Senftleben from the University of Amsterdam in the Netherlands. Martin is a professor of copyright law. I have known Martin for a very long time because we both worked in WIPO. And at the time, Martin was a professional sent from the German government after a PhD at Max Planck in IP, focusing mainly on trademarks. We had many lovely debates about the differences between the German and the Austrian way of speaking German. Sophie Kreppe von Rosen is with the Intellectual Property Office of Sweden, and she's also the registrar for all the collecting societies of Sweden and is responsible for them. And Sophie has a legal background, obviously, and she has worked in New York and in Paris, and has a strong interest in cultural heritage policy. And Sophie and I, we have discussed an awful lot about copyright and artificial intelligence and copyright in general in a Swedish context. And we think the time is very ready for Sweden to embrace these questions from a public policy perspective and from a governance perspective. We also have on the panel Mark Trapphagen. I hope I pronounced that rightly. Mark has joined us today from Washington, D.C. Mark is a lawyer in private practice, and Mark is also a lecturer with George Washington University on copyright matters and IP matters. And Mark, I apologize, it was too short notice for us to still change all the advertisement, but I think it is wonderful that you've been able to join the panel and that you can add your perspectives. So we have a genuinely international view on it. For those who don't know Oxfirst, Oxfirst is an economic consultancy specialized on intellectual property and competition law. We provide economic testimonials for litigation and licensing purposes. We have been the economic experts in at least 2 landmark cases in intellectual property in the United Kingdom and in Canada. And other than being involved in litigation and arbitration and mediation, we also are quite involved in public policy work and in providing economic evidence for factual policy purposes. At least that is the goal eventually. And we run a conference once a year, and I'm really pleased to let you know that the next conference that we'll be holding will be in June in Munich in 2023, more second half of June. And we are planning to address these questions also in our Munich conference, and I hope you will be joining us there as well. Oxfirst is based in Oxford and in London. It's been now live for over 2 decades. And Oxfirst, and yeah, what else is to say? Oxfirst was started by academics from Oxford University, and we thought as world of intellectual property and competition law is too important to just be left to lawyers alone. It's important to provide economic insights also and provide forecasts and numbers and data to crunch around and give an idea of where all of this could be heading from an economic perspective. And we work with governments in the UK, in Germany, in Austria, in the US, all over the place a bit, and obviously in Brussels and in Geneva to give new ideas on intellectual property, on IP-nomics. If you're in any way interested to get involved, to discuss, to debate with us, to also propose seminars, if you want to get involved in our Brussels or Munich conference, please do let us know. I think I've said enough now on just a general intro. So let me start by opening here. So what's going on in copyright and artificial intelligence? Why is this such a hot topic? What are the issues here? What are you seeing here? Sophie, from your perspective, what are the issues from a governance point of view?
What a nice broad question to start off with. From a governance perspective, I would revert a little bit back. I think that during the past year, I've been to seminars and conferences, and they all have the same title, kind of copyright and AI, copyright, AI, and licensing. And I think it's quite telling of a subject that's somehow in the flux. It's moving, that is being defined now. And I think what's going on within copyright and AI, of course, it depends on what part of AI you talk about. AI being a discipline of computer science, it's I've been invited to speak on seminars where we've been talking about image manipulation and image manipulation detection, and that's been the focus. And then other seminars, we've been talking about text and data mining, yet other ones, it's been about generative AI. So I think that, copyright and AI, what happens there, it's such a huge field. Right now, from where I'm sitting, Sweden was quite late in transposing the DSM directive. And a lot of discussions have, of course, been taking place around text and data mining, Article 3 and 4. But as Martin pointed out before we spoke, before the seminar, those were written before generative AI. And I would say that the biggest concerns from the stakeholders that I speak to now, or the hottest topic, is just the question of generative AI. And it was a funny article published in The Guardian yesterday by, it's about a film about AI, made by AI. It's Alan Warburton, who's the producer of that film, together with AI. And he was talking about the wonder camp and the panic camp. And I think that's kind of telling, the debate in AI now, AI and copyright, it seems to focus a lot on generative AI and the potential fears that the creative sector, that maybe governments are feeling with regard to this new phenomenon. When we come to copyright issues, again, there's a wide variety of issues. I think that when I looked back at conferences about 1 year ago, there was still some discussions about originality and, AI output. How should we look at that? I feel that that's kind of put aside now, and the discussion seems to be drifting more towards potential effects. But of course, the copyright doctrine questions, societal matters that were traditionally regulated by copyright frameworks, or market issues. I know that, Roya, you and I have been talking about the fact that there are new stakeholders. And if you ask me from a governance perspective, what's difficult? Well, my role in comparison to maybe Professor Martin and Mark, I don't represent clients. I don't represent one part. I kind of have a duty to be neutral, to understand the field. And when it comes to copyright and AI, I think that's what concerns me the most, that we have new stakeholders, new actors, new business models, new incentive structures, and coming to kind of the core of copyright. Copyright is about drawing a balance. It always has been. And if you have to be engaged in a debate where you have to draw a balance, or you have to kind of try to push people to behave in one way rather than the other, it is a challenge, like being in this AI field because you think you understand the actors, and all of a sudden it's a new entity coming up. So I think I will leave it at that as a kind of introduction to what do I feel, what do I see when I see copyright and AI on a table. Now you're muted, Roya.
Again, so Mark, where do you see the big governance challenges in this field?
Well, where to start?
Yeah.
I know.
It's all out there. I mean, Roya, you have mentioned the AI Act that is in the making in the European Union. That's a new piece of legislation that at the very beginning was not designed to regulate generative AI and questions of copyright, but it now has become an aspect of this as well. But that's a discussion that is very much about transparency and attribution questions, like which copyright protected materials have been used in the training process, and is there proper attribution for the human resources that have been used for AI training. I guess we also have an upcoming discussion on liability questions, like if generative AI creates all types of problematic output, who is then responsible for this? Would the provider of AI generative services be directly liable for everything that the system potentially creates? Two questions. I mean, we have to, at some point, just focus on some of the issues. So what I find particularly fascinating is one policy issue. I would like to see these generative AI systems really to flourish. So what I find problematic is if we now at the beginning where this whole process starts, we already say, no, you must not do this, you can't go in that direction and so on. And at the same time, I think it would be a pity if in AI training, certain repertoires like the European repertoire or something would be excluded from the outset. So for instance, if we as a European community of copyright owners take the position that European content must not be used for AI training altogether, then this is missing, and this is missing in a tool that is likely to become a very powerful tool for generating all types of literary and artistic content. I think in the future, artistic practice can change a lot by simply the fact that we can ask the system to create a template first, and then based on what the system creates, we add certain finishing touches or something. But the core idea or the core concept comes from the system, from the generative AI system. And then if European content is not in this repertoire, then I think we would just marginalize ourselves. So that's something that I find is really an important policy question, like how can we ensure that a broad spectrum of works is available for AI training? But then if we take that step, in the sense of a quid pro quo, I would like to make sure that there's also money flowing back. Like if a diversity of resources is available for AI training, then at some point, the generative AI industry should also be bound to channel money back to the creative industries, and in particular also to individual creators, so that those works and concepts, ideas, styles, and so on that are finally reflected in AI output also get remunerated. And then, I mean, we can discuss the details on how to arrive at practical solutions here, whether to take the training process as a starting point for putting a type of a tax or levy on generative AI systems, or whether you look at the output level and you say the moment generative AI products and services are offered in the marketplace, that's the moment where copyright enters the picture and imposes some remuneration obligation. But I mean, as a final point, I'm idealistic enough to say that I would like to see human creativity survive this. I mean, to some extent, it's clear that there will be replacement effects, substitution effects, and also for society as a whole, I think human creativity, human literary and artistic works have particular societal value. So whatever happens, we must make sure that this survives. Perhaps this helps the discussion as an opening statement.
Yeah, Mark, what's your take?
Well, Royal, first of all, let me thank you and the Oxfirst for inviting me to be on the panel today with Martin and Sophie. I really appreciate the opportunity. I guess I also need to say that the views I'm going to express are my own, and they're not necessarily representative of my clients or of the George Washington University. So, with that said, okay, there's a number of sort of specific copyright and related right issues that are presented by the use of copyrighted works in developing training models, data sets, and and the output that may result from them. And those are all things to discuss. I guess to start, at a general level, I have a view that the issue, of course, goes beyond copyright. It certainly goes, toward related rights, performers' rights, etc. But to pick up one of the things that Martin has said, there are bound to be substitution effects, and that's where I think a consideration of artificial intelligence by governments, in my opinion, should also consider labor factors, because I think that we didn't have the opportunity back when sound recording and radio came along to sort of consider that there would be fewer bands performing in nightclubs, or in church halls. There was a way to address that, through the performance rights for musical compositions, which was great. Here we have the potential for there not to be a need for a number of people who actually make their day-to-day living in the graphic arts, in music composition, in sort of the fields that we don't see dominating the headlines, but nonetheless, are human beings contributing their labor toward items like advertising, background music, film scoring, etc. So beyond the copyright issues and beyond issues of compensation and liability, I think that in considering the benefits for example, healthcare or administration of complex systems, the governments are probably also ought to be attuned to some of these issues of labor displacement. And that's one of the issues that I see sort of in the larger sense. With respect to copyright, I think that we have a couple of the most urgent issues are reaching some sort of resolution on a couple of questions. One is whether the reproduction and modification of copyrighted works in preparing training sets and AI models constitutes infringement of an exclusive right of copyright. And if it does, whether there's a limitation or exception that currently applies to that activity, or a limitation or exception that should apply to that activity. And I think the other issue is really related to the ownership of AI output, which is who, assuming, as we've seen in the United States, that a work or I'll call it an image or text that is created exclusively by a machine does not qualify for copyright protection under current US law. Now, nature and the law abhor a vacuum. So the question is, if these works are not protected by copyright, are there any legal rights that do exist in them? And if so, who is the owner? And so, at least here in the United States, we have a lot of work going on by the Copyright Office, and outside of copyright, the Patent and Trademark Office and the National Institute for Standards on many of these issues. But we've also got the courts who are actually stepping in to deliver some guidance, and whether policymakers follow that guidance in the long run or change the legal environment, those court rulings, in my opinion, are going to at least shape the debate and have an effect on the discussion. That's my opening statement. So
you touched upon a lot of ground, which is what happens when you ask an open, wide question. Perhaps we could narrow it a little bit down. In debates, I had coffee breaks, as one has usually in Brussels. I understood that the question of transparency is becoming more and more prominent as an issue, and that there is a discussion in terms of adequately disclosing whatever has been aggregated and used for artificial intelligence and big data analytics. And I think this is one of the questions which are currently occupying quite a few people. What is your opinion on the question of transparency?
Can I just jump in?
Sure.
Well, I of course I follow the transparency issue as well, and again definitely from the rights holders organization that I speak to, that's a big issue. But mainly it's a big issue because I feel that there's a concern that copyright in the discussion, like Mark was saying now about exemptions or potential defenses. I think that from the rights holders' perspective, that the ones I speak to, there's concern to show that there should be licensing opportunities. And I come from Sweden, which is the country of extended collective licenses. We like licenses. We don't have the fair use doctrine. We don't really understand it that much, or I don't at least. So I think that transparency from our perspective, it is an important requirement, because of course, how can you even start negotiations regarding a license unless you have transparency, unless you know what's behind the use. That said, I agree with Martin as well in terms of that we all want innovation to flourish. We don't want to be left behind. And I think it's interesting to hear from Mark there, because I think since I started working within copyright, we've always compared ourselves to the US. It's always been kind of, it's so important that we don't get left behind. We want to be as good as you are. So it is interesting to see what your concerns are.
That's interesting, because throughout my career, the US has often been playing catch up on intellectual property with the European Commission. So that's
it's good that we're talking now. But back to your question, Roy, about transparency, I think it's of course it's about responsibility as well. It's like what Martin was saying too, that authorship throws back to Statute of Anne. Authorships comes, you have a right to something, but then you have a duty as well. And of course, transparency becomes an issue in many ways, not just with regard to copyright, but definitely for licensing purposes, I would say.
Yeah, but I mean, as much as this is a legitimate question, I fully agree with what Sophie has just said. At the same time, very clear, we must be realistic here. We are not speaking about training sets that cover just a couple of works or just the work of one or two authors or something. If I understand what I'm not a specialist in terms of technology and algorithms and foundation models and what have you, but it seems that we are speaking about large numbers of training resources, also self-learning systems, which look for additional materials themselves. So to tell a developer of the foundation model to give full transparency about what has been used for training purposes seems to be an almost impossible task. Then you also see this in the current proposal, that is the AI Act. It speaks about summaries and so on, whatever that may mean, and how meaningful summaries then can be. And then we must not forget that copyright is just one thing. You also have trade secret issues here. I can imagine that the choice of training resources is something that gives the individual systems quite some competitive edge. Which mix of resources, where do you get the inspiration for the system from? So, I mean, in a nutshell, I'm not even sure if this should be the most prominent question. This is why I'm always wondering whether, instead of following the traditional licensing and we negotiate about an individual amount per work that has been used, which makes perfect sense in traditional copyright thinking and so on, but still I'm wondering whether in this situation it wouldn't be just more realistic to say, let's speak about a flat rate, a lump sum solution, which brings in collective management organizations and repartitioning schemes. Of course, you get the same problem at the back end. I mean, once the money, the remuneration comes in from the AI industry, somebody has to decide on how to then redistribute the money. So I'm not saying that you can escape transparency questions, but honestly speaking, just from the perspective of what I hear, how these systems work and so on, I'm wondering how fruitful a transparency standard can be if it's technology that by definition does not offer lots and lots of transparency, and that may also have countervailing values like trade secret protection and so on.
I'm in deep waters now, because I recently just read about the Chinese proposal, that there's some kind of disclosure. You have to kind of disclose the source. That doesn't mean that you have to disclose everything that you train your AI on, but you have to kind of give. Does any of you know anything about that? I should have Googled it before this seminar, but it seemed really interesting.
Yeah, that is news to me. That's yeah, one of the, this is, I mean, but you raise an interesting point as well, that there's and again, to harken back a little bit to the past. I mean, in addition to being an IP issue, we potentially have a trade issue, with respect to the use of all sorts of intellectual property in training models and then their deployment through AI. That being said, let me approach or introduce another point, which is, one of my thoughts or observations is that much of this debate is being driven by AI generators like DALL-E and ChatGPT, which are essentially demonstration models that are used by consumers. Okay? But what I see in terms of what businesses are doing to actually deploy or use AI in their businesses, and the way their vendors are responding or addressing the demand, seems much more focused. Like, for example, every morning I listen to the news, and there's advertising by a computer software developer. And what I see between that advertising and also in law firms in the United States is a desire to produce AI models that are built upon one's own proprietary information. So, for example, large law firms here in the United States can engage with vendors to develop knowledge bases and AI models based entirely on their own output, briefs that have been written, research memos that have been written within the firm, where there aren't issues of intellectual property, or there's at least a standing license in the case of like research institutes, and that they're using that, and that's the way business is addressing this, in a way that's different from sort of venture capital driven consumer demonstration, which is really what's propelling the debate. And so occasionally I wonder why that is, and whether our debate is a side effect of what was sort of perceived to be a very early release of AI as a consumer product in order to grow a user base and to also attract venture capital. And and I think it's important to sort of keep that environment in mind as we're talking about the way AI may actually be deployed, in a way that's valuable for people who will actually pay for it. Anyone have any thoughts about that?
One, it's a quote. I think Daniel Gervais wrote an article, The Machine as Author. And in that article, there's a funny quote. It's, I should have it somewhere. It's a Professor Bridie who says, that, is this dystopian vision of literary markets saturated by machine anchored drivel merely a moment of historical anxiety within the creative class? So I kind of, when I hear you, I was thinking like, well, is that what you mean, that maybe we're giving too much focus on something which move forward a few years, it won't be that bad, it would be us, I definitely say that I will belong to this
well, yeah, and I think it actually addresses, though, more than just the rights holders, stakeholders, because it also gives some insight into what's driving the AI development community to to want to sort of secure a fairly expansive field of use, to sort of progress the work, but it's being presented as a choice between terribles, which is, oh yes, if we are able to pretty freely use all of this information and civilizational and cultural artifacts to assemble a language or image model, then there will be these wonderful benefits, for society as a whole, which sounds great. But I think that what's actually going to be the commercial aspect to begin with is not going to be, ChatGPT as a consumer product. It's really going to be those applications that are a little more tailored. One of the this commercial I hear every morning for an AI vendor to come into your organization and work to develop your own AI model in-house, promises that what they will deliver is hallucination free and IP liability free, because you're using your own data, and if that's the commercial aspect, I mean, where people are actually paying rather than a public deployment to secure market share based on venture capital, those are two different kinds of applications. And it makes me wonder if the real benefits of AI require such an expansive safeguards as are being requested, safeguards from liability. I mean, for society as a whole to obtain the benefits of AI, do we really need to provide such safeguards for use of our cultural artifacts?
Yeah, but I mean, there is a broader societal dimension. I mean, which brings me back to the replacement effects that we have discussed earlier. Of course, I mean, we have seen replacement effects in other sectors as well. I mean, the car industry is one example, and the machines took over the assembling of the cars, and many people were out of work and so on, and we have survived this in some way or the other. But this is different because it's about literary and artistic expression. It's about the way we communicate. It's the way we shape ideas and so on. So the moment we leave part of this to the machine, it's not only about liability questions and about questions of what kind of potential implications this has for certain business models and so on. It's very much about the way we see the world. And if the basic ideas that we express in literary and artistic works no longer come genuinely from humans, but the templates that will come from machines who are basically recombination machines. I mean, generative AI systems are like echo chambers. They give you reflections on something they have digested and analyzed, and then it looks very much like a human expression, but it's mimicking human expression, something we already know. So we lose basically many of the avant-garde impulses, the surprising reflections on societal political conditions, which machines will never offer because they don't suffer these societal conditions as we do as humans. And so that's
I agree with you.
I'm not sure to which extent copyright is the right policy to tackle issues in that area, but that's really a broader, I think, quite worrying perspective, because we humans, by definition, we are a bit lazy, if you're honest. I mean, with navigation tools coming up, nobody any longer looks for how a city is actually put together and how to find your way. You just use the machine to say, I want to get from A to B, and then the machine does the job. And we will lose our capacity to communicate, to build these literary artistic works ourselves when we leave the first template to the machine.
I agree with you, Martin. And, and yes, I do wonder if, I think it would be expecting too much for copyright to address all those issues. It really is a lot bigger. The point you're making in my opinion, has an interesting effect on within copyright, which is, we already, at least in an everyday infringement analysis in the United States, are under an obligation when we go to court. But the court has an obligation to filter, what is expression and thus protected by copyright from what is not expression or original expression. For example, matter that is excluded from protection by the idea fact dichotomy, or idea expression dichotomy. So I think that the interesting thing about having works made more and more first draft, maybe second draft, then edited, polished by humans, does raise this question. Well, it sort of accentuates the analysis that we already need to do, which is, what is protectable in this work that combines both protected and unprotected material? And full use of AI to its maximum in everyday items like encyclopedia articles or advertising or background music or film score is going to really exacerbate that question, and at least in the US will lead to lots of expensive discovery in court, on a very practical level. I don't know what under most of the in for example Sweden or in Holland, how would that be addressed? Which is sort of deciding when something is copied, like a literary work, what parts of it can be protected against unauthorized copying, assuming that assuming it may fall outside an exception.
We were intending to talk about governance, social market, and antitrust matters. We are still on the governance side.
Yeah.
We may need actually 4 webinars instead of 1. If I'm coming back to the governance question, I mean, Europe has been priding itself that at least it has some preparatory work already done around this matter for better or for worse. For some people were very happy, other people were unhappy. I'm thinking about the text and data mining questions around Article 3 and Article 4 of the DSM directive, the exceptions and limitations for text and data mining, which is probably most commonly connected with copyright and AI. If Europe were to open the copyright directive again, what would be the 3 key issues that we should be addressing in Europe?
Well, first of all, as far as I know, chances of reopening this copyright in the digital market directive anytime soon are very theoretical. Everybody seems to be so much exhausted about the whole process that was necessary to arrive at the current rules. So I wouldn't expect any changes to the rules. Which brings me to the first point. In Article 4, this is the general open text and data mining provision, in the sense that everybody can rely on that one unless copyright has been reserved. The central mechanism is an opt-out mechanism. So as a right holder who does not want his works to be used for AI training purposes, you can opt out. Seems to make sense at first glance, but considering the broader policy scheme, I'm not so sure if this is a very clever solution, because an opt-out, first of all, means that you take certain repertoire, certain works out of the pool of works that are available for training purposes. Personally, I find this is quite a pity, because I would like to see these AI systems fully developed. On top of that, speaking about competition between different regions for high-tech industries, a legal solution like in the US that is more flexible, in the sense that based on the fair use doctrine or whatever, you can discuss this before the courts. Other regions outside the European Union might be more attractive to AI developers if no opt-out is possible, and in principle you can use all the resources available. So I'm not so sure if this opt-out model that has been adopted in Article 4 of the directive is such a good idea. So if there is one thing that I could change now that we have full knowledge about, or at least have knowledge about the early days of the generative AI systems, I would like to see the discussion reopened on opt-out, because from my perspective, it makes more sense to go to the output stage, which Mark has just mentioned in his last comment, and start regulating there. Mark, just a quick answer to your question, how would we look at infringement questions in Europe? Pretty much the same way. So idea expression dichotomy is very similar based on the international treaties to what you have in the US. As long as you find traces of protected individual expression, which would mean individual creative choices that you can trace back to a pre-existing work, you would find infringement. But if it's only general style, concepts and so on, then it would be freely available material.
Yeah.
Having said that, there is one fascinating theory that has been developed in continental Europe during the last century, and that's the idea that you could introduce at least remuneration schemes based on the idea that even public domain resources, like generally available styles and so on, can be subject to a compensation remuneration obligation. And then the right holder would be the community of living authors who should be able to benefit from the achievements from the past, the literary artistic domain in a broader sense. That's the domaine public payant. We have nice French expressions for these types of concepts. So that's something that you could try to revive in that particular area. But apart from that, I think the basic starting points for deciding on output is quite similar across both sides of the Atlantic.
So Martin, we are well prepared in Europe, basically. No need for further action.
No, I don't like the opt-out thing. I think we should move to output-related solutions. So that's,
okay.
That's what I would.
Martin, I could mention that, as I think Roy might have said, I worked with resale right before. And correct me if I'm wrong, but I do think that there's such a fee in Norway, like a resale right royalty, but on works that are no longer under protection. And the idea is still the same. The idea is to kind of contribute to the general ecosystem of the authors. And here I almost wish to quote you, Mark, when we spoke, and you were saying how it is interesting how AI and copyright, AI has got the copyright debate to like venture into larger questions of societal concerns. Normally, copyright lawyers, we have focused on the IP aspects of things. Again, exceptions, limitations, opt-out licensing. And now we're starting to talk about the consequences of these regulations for society at large, which I think that when, Roya, when you first talked about this seminar, this discussion, you were asking us about opportunities and risks that AI poses for copyright. And I was thinking that one of the opportunities is that it forces us to ask the question why we have copyright in the first place, why we have these regimes, what are the societal value of them, which is, it's so easy to forget to ask those basic questions. And once we can agree on that, then we can start looking into solutions, be they on input or on output, like this levy system. Hope I didn't misquote you, Mark.
No. Thanks. At the risk, at the risk of taking this conversation far outside of copyright, what I mentioned to Sophie yesterday was that throughout my career, starting in about the mid-1980s, at least in the United States, that was the beginning of copyright being treated as an asset that was important in international trade. It was the beginning of sort of the trade revolution in intellectual property, which immediately got started with negotiation of the TRIPS agreement. And that whole venture, that whole progression has had a great deal of value. But I think that, and the value has been that it's in addition to the human element involved, at least in copyright, but I think also in scientific discoveries like patents and even commercial advertising and branding. In addition to that treatment and recognition of it as an asset, as well as a human expression, we don't often talk about it as being the result of labor. Our current economic model seems based on two aspects at least: capital, labor, and then if you want to take a third, it'd be investment. But that's a form of capital. And I think that this issue of copyright and artificial intelligence sort of asks us to think about that, and think about some of the ecosystem, which is, how valuable is it for society, if at all, for there to be a middle class of artists? There will always be, the world beaters, but is there some societal gain by having, a substantial number of people who are able to make a living composing music, whether it be a film score or whether it be an advertising jingle, or visual artists, even if what they're doing most of the time to pay their mortgage is that they're doing designs for flyers or newspapers. And I think that's a question, I would like to see addressed. And I think it'll also come up in other fields, especially as cybernetics begins to merge with artificial intelligence. And you're like, we really don't need people in the warehouse, even.
But you see, Mike, if I may jump in directly, we already have a couple of answers to this. I mean, not in the legal discipline, we would have to look into cultural sciences and so on, but there are quite a couple of studies showing that just for us human beings working with literary and artistic materials, doing things ourselves, being creative ourselves, this makes us different people. And it's not about pressing the button and telling the machine what to do, but really doing it yourself, like for self-actualization, life satisfaction and so on. It seems really important that we do it ourselves. So by leaving it to the machine, we lose something in terms of life experience and engagement in discourse in society. So I fully agree. I just think that there are already quite a couple of answers out there. I'm not so sure if these are answers simply of capital factors. We would need a broader economic approach that also includes research on other factors that are important to, well, behavior in society and things that make us as citizens, as people, better.
Yeah.
I think it's I will jump in there now. I hope you don't mind, but we've been doing some capacity building work in countries where the copyright infrastructure is lacking. And I think that when I've been visiting countries who are trying to build up this copyright infrastructure from scratch, it has kind of struck me how, well, what's suffering when there is no copyright infrastructure? Well, the critical media being one. If all television productions, all newspaper productions are just based out of handouts from the government, and all of a sudden I've started kind of venturing into the copyright, the aspects of copyright that's related to freedom of speech, freedom of expression, democratic values in society. But again, I think that, like Mark was saying, the AI debate has pushed me to think of those issues in a way that I didn't need to before. So yeah.
Yeah, it's interesting because I think that look, the U.S. Copyright Office has been asking for comments on a number of questions related to AI. If you count all the subparts, it is over 60 questions. Okay, ranging from areas like questions about input and whether fair use applies in developing models. The output, the generative AI output and infringement and labeling, and questions of disclosure, sort of like as being proposed in the AI Act. Questions about style protection and name, image, and likeness protection that normally go outside of copyright. But there are general questions at the beginning, the 4 questions, and they actually ask, please list, what you think are the societal benefits, of deployment of artificial intelligence with respect to copyrighted works. And what do you think the effects will be on artists, authors, researchers, technology companies, and the public? So, there is room, at least, in the inquiry in the United States, for that to be expressed. I haven't seen very much of that. There's over 10,000 comments, and the reply comments ended yesterday. So there's a huge amount of material. But I think this is important. I don't know what the capacity of government currently is for this. At least in the US, we are very, sort of quantitative and economically driven on policymaking. And also probably the elephant in the room is that our policymaking is also driven in part by geopolitical concerns and deployment of AI in defense and weapons. And so it'll be, I don't think any of us in the copyright related rights community are going to be really knowledgeable or have an opportunity to be involved in decisions like that may have knock-on effects with respect to our world of intellectual property. So that's, so we are dealing with a bit of a black box with some of these questions.
So what do you expect will be the deliverable from the consultation from the US Copyright Office? And what do you expect, and what would you like to see as a deliverable?
Yeah, it actually, the inquiry was remarkably detailed, and because there was a number of questions asking for specific technical information about how training works. What are the steps involved? And later on there were questions about, all right, assuming all of this, how would fair use, our general circumstance-based exception, apply to these activities? but but really the remarkable thing was the request for information about, please tell us how this black box works to the extent you can, so that we can understand it, and then decide whether unconsented reproduction in use of training these models, really exists, which I understand it does. And then, how does that fit in with a fair use analysis that, principally the focus is on, all right, what is the purpose of the unconsented use, and that takes into account a public benefit. And then there's also one of the typical 4 factors. The other one that's principal is, what is the likely effect on the market or the value of the works being copied? And
But hasn't
and
that
there's
changed?
an awful lot in there. There's an awful lot in there, which I think, great questions. We don't, in many respects, we really don't know. Right, Martin? I mean, you were talking about output, and also that's very circumstantial. How do we know, show it to me and I'll decide if it's infringement.
Yeah.
But
Yeah, but speaking about the fair use factors, I mean, we have seen a couple of first text and data mining decisions that were very much in favor of freedom of text and data mining. But now with generative AI and potential impact on the market for the source materials, the fair use analysis may change. I don't know. I mean, case precedents are important, but the case precedents have not considered generative AI systems capable of substituting human works. And as far as I understood previous fair use decisions, substitution effects are taken seriously in these factor analyses.
And it seems like a risky business. I was saying it's a risky business to create your business strategy on the basis of a defense.
Yeah.
Generally.
Martin and Sophie, perhaps you can make this clear to me. I understand that the TDM exception was conceived and implemented, for the purpose of really promoting finding patterns in existing databases. It was perceived as a need to provide an explicit exception to the database directive sui generis right, in order for research institutions to make a substantial extraction in order to find the missing patterns within that it really wasn't, we didn't know that AI would be a possible candidate for the application of the TDM exception. Is that true, or is that just a folk tale I've heard?
I'm not so sure if the focus was exclusively on the sui generis database, right? I mean, first of all, what you find in also the research provision Article 3 is a lawful access requirement.
Exactly. Yeah.
So, I mean,
it's things that you already have.
you don't get an initial access right. You have to first get a subscription or something that would qualify as lawful access. And for the rest, I think, yeah, of course you can say that reproductions taking place in TDM training processes do not always have copyright relevance, but in Europe there was at least a growing consensus on that making pre-existing works and harmonizing them so that they can be training materials, so the training corpora, that this would have copyright relevance. So that, from my perspective, has been very much the starting point for the TDM exceptions. Whether it is such a good regulatory idea to say that it is a relevant reproduction in the sense of copyright, that's a different thing. But in Europe, it seems that at least this point has been settled. But I don't know, Sophie, you have implemented the whole thing in Sweden, so.
Well, no, I've heard all sorts of reasons. I was being, remember Martin, I was saying that maybe they didn't want to make it well suited enough because they wanted us to complement it with licenses. but no, I'm coming back to the same point as you regarding the fact that it's lawful access. So it's giving certain limited groups, with regard to Article 3 at least, the ability to do something with works that they already have a license to.
That's a good point. That's a good point. I had forgotten that. Thank you.
I heard that as an argument. Someone who was in favor of extending the extension and was saying like, well, that would lead to more licensing, because more people would want to license material, because once you had a license to material, you could then do text and data mining. But again, I think that what we're discussing now is like, what were the thoughts then, and what is the reality now? The reality now is different. Artificial intelligence and generative AI brings up a whole different points of questions. I'm wondering, I can see.
Yeah, I fear we have run out of time, but we have 7 questions. We can run a few minutes over time, but then I think we should stop. I have looked at these questions quickly. There was one question whether you think actually that if AI keeps scrapping over copyrighted material, if without permission or consent, if this is per se a copyright infringement. Then there was also a comment on the UK High Court, which ruled this month that the Getty Images versus Stability AI case could move to trial. And then there's another question. Again, the outcomes of a series of AI-related cases such as Tremblay, Silverman, Universal Music, and Getty Images in the United States. Well, we'll have to see, I guess. There's a comment on the opt-out of Article 4, and that this is actually an anomaly, as machines cannot unlearn. So for any copyright protected works interested already, they can't be opted out after the machine learning takes place and the program is released to the public. Opting in is the consensual option for right holders. Then there's a question around the TDM exception is being challenged in context of AI training by right holders, and the EC is discussing with us. Feel free. I apologize, we have so little time left, because each of these questions is really important and very legitimate to discuss.
And they could all motivate a lovely long essay or thesis.
Yeah.
How are these essays, are these questions being recorded, or somehow can we reply to them in writing, giving our thoughts on them, or how does it work?
Yeah, you could comment now, but we can try to pass them on to you also.
I have 2 short comments. One is on the Article 4 and machines can't unlearn. That's a very good point, and that's something that we hear now very often. And it's true. I mean, the Article 4 of the DSM directive comes too late for many of the systems that have already been trained. You can opt out at this point in time, but this doesn't change the input that has already been used for existing systems. So that brings me back to my general skepticism concerning opt-out solutions. It's just too late for opting out now in many cases. And the second point, can you scrape what is freely available on the internet? Well, we have recital 14 of the Copyright in Digital Single Market Directive that tells us if material is freely available online, that's considered lawful access. So I guess that's okay. Another thing is that Article 4 of the directive says lawfully accessible, doesn't say lawful access. So we are not entirely sure what that little difference means. But as I said, I mean, as long as it's freely available resources that you mine, that should be okay. I wouldn't recommend hacking technical protection measures. So if there is a paywall and an electronic fence around things, better not to go there, I think.
Yeah.
And that kind of, it stops us from going into the more important questions. How do we want it in the future? I think that's the most important question, to look forward a little bit.
Say, Martin, I just, with respect to the question of unlearning, I don't know how accurate this is or whether it's practicable, but recently at a Copyright Society lecture in Washington, D.C., Justin Hughes of Cardozo observed that actually material can be excised from existing models. Now, and he was quite insistent on that point. Now, I don't, so there may be a question of fact involved here that I am not privy to, but I just wanted to, apparently there is a difference of opinion, and I don't know which is more accurate. So, yeah.
Future checks now.
I think we have
So,
run out of time. I think I can offer each of you a last final statement, and then we should close it because we keep losing also our audience.
Sure.
So what's your final snapshots, Sophie? What's going to happen in Sweden now?
What's going to happen in Sweden? I don't know. Oh, I thought you meant final snapshots.
Well, your personal take.
No, my personal point of view is that it's. I was concerned. I am concerned a little bit still about the polarized debate, and every now and then I think, well, it's just part of changes. When something new comes up, we have a polarized debate, and it makes me think about when Article 17 was being discussed in Sweden. My daughter, they had a sit-down protest, like Greta Thunberg, in the school against Article 17. And then once it's there, people get into business and they're not that concerned. So part of me is thinking like, well, these are really important issues. They are about innovation. They are about the future. They are about democratic society. And, is this polarized situation that I find myself in sometimes, is it blurring the real issues? Is it blurring, stopping us from really showing and understanding the concerns? These kind of discussions makes me less worried. I think that here we are understanding the issue better, and then hopefully this polarization will people will get closer to each other when we will have this. We can all agree on that what we want as the end result. So that's my personal kind of thought on these kind of debates. This issue. It's not what will happen in Sweden. Well, what will happen in Sweden? I spoke to our Minister of Justice just today, and I know our Minister of Culture as well are mapping out the stakeholders. They're speaking to the stakeholders. They're taking in input, a little bit like the consultation maybe, but in a smaller scale because we're a very tiny country. But we are still at that stage, trying to understand the different actors in this field, which is, I think, is a clever thing to do, since again we have to draw a balance that's not just okay for now, but I think that we all can agree that we want a long-term sustainable kind of regulatory framework for these issues. So that's what's happening in Sweden right now.
Good. I think then I would like to thank everyone for joining us today, and even though we went over time, for still staying on the seminar. We have our next seminar. We are very sporty in December is our seminar week. We have We have next week a seminar with the US Patent and Trademark Office on secondary markets and IP evaluation and recent research the USPTO has undertaken and how people commercialize and monetize intellectual property. And their findings are quite different from the findings from the European Commission. If you're still in the mood before Christmas, please join us for our USPTO webinar as well. Other than that, our next webinar then afterwards in January is with the global head of litigation from Novartis, discussing about corporate social responsibility and what they're doing to ensure access to patents in low and mid-income countries, and that how they're making available their patents on cancer-related technology and medication to low and mid-income countries. So nothing around litigation, even though we have the litigation man in the call. With all of this being said, again, this was an excellent, super great panel. Thank you very much for joining us, especially the preparations are just as much fun as the actual discussion. Please feel free to email us. I'm very happy to pass on also questions or to reach out directly to Sophie, Martin, or Mark, or myself. And yeah, Merry Christmas and Happy New Year in case you don't join our events again before the next year. And thanks a lot for joining again. Okay, have a lovely afternoon still.
Thank you.
Bye.
Thank you for putting this together, Roya. Thanks.
Thank you very much.
Thank you for joining.
Great
Bye.
discussing this. Bye.
Bye.